further hearing in the appeal of Manchester City Council against Pinnock.
You should have on your table that the amended headings as asked by Lord Brown.
I'm grateful. Thank you very much.
Mr. Manning. I'm only going to spend a few more minutes on the second head, but I do need to go back to it a little bit to put it in context, which was the consequences, really, in effect. Summarising what we were saying yesterday is the very availability of the conventional argument is what will justify the representation, is what will require the time, and so on. And although there is this practice direction of the CPR, there's an extent to which that's quite a sort of target duty. I mean, cases are in the list for the district judge. That's exactly what happened here. Case was in the list for the district judge. Mr. Stark turned up with a defence. Mr. Manning said, well, can we have 10 minutes and I will convince you that there's nothing in this. He said, well, I haven't got 10 minutes if it's not in the list. So it is not nothing. And as to the starting point, Mr. Travell says, Mr. Luberdock says, the secure tenancy is different. It's very different because the secure tenancy is not to be lost. But Article 8 also says it's an extreme measure to evict someone. So we do say it is going to have an impact. And if you look at Maloney Friend's printed case at 32, the questions which he asks there are all questions that he asks on a reasonableness challenge.
Which done it.
Sorry, we're looking at his argument work.
The printed case at 32.
Is this Mr. Luber or?
No, Mr.
Paragraph 32.
Gravel.
Yes, what the question of proportionality involves, the various points that he says would be raised.
Well,
that's what he
yes,
says.
but they're all raised on a reasonableness hearing anyway, or should be. Lord, just dealing with one minor point, Mr. Luber has the advantage of youth. He wasn't actually practising in 1980. The county courts did not suddenly take on a new jurisdiction without considerable additional resources and difficulty, and so on. He's just been called, he tells me then. But I don't want to be accused of exaggerating. I'm not saying every case will have this effect.
When most of these points, indeed in this case, for example, have been taken into account when considering whether to make the demotion order.
And again, most of them would have been taken into account by the panel. They say there have been previous proceedings and so on.
But which of these wouldn't have been taken into account when deciding to make the demotion order?
I'm saying none of them wouldn't.
Quite.
It's not my argument.
No, but they would have been, and in practice they would have been as well.
Yeah.
Yeah.
I mean, even
So the court wouldn't need to address it again when considering whether to make a possession order. That they'd all been decided in order to make the demotion order. Yeah. So the decision to make him vulnerable to an outright order for possession took into account all these factors, and therefore they don't need to be taken into account.
We agree with that, but people will argue other circumstances.
Well, circumstances may have changed between the making of the demotion order. That would be the exceptional sort of case.
Yes. But the law, the difficulty with the proposition that everything is exceptional is that all cases are individually different. Lord, the point I'm making, I'm not saying it will be every case.
No.
I'm saying it will need to be considered in every case and taken seriously in every case by the solicitors. And if they get enough together to suggest there may be an argument that will generate additional cost and delay to us, I'm not saying, and I did want to open by saying that, I'm not saying it's going to be every case. I'm also very mindful of a proposition Lady Hale made yesterday. In a sense, I spoke of something I'm afraid I forgot, but so what? If it is expensive, that is the consequence. Our point, as you'll appreciate, we are seeking, if we do not win on our first point, realistically, we are looking for a declaration of incompatibility. Yeah. And the reason we do so is because when Parliament addresses it, it will have to address the cost implications. In particular, The financial and other implications. The financial cost is self-evident. When it does arise, we are clearly adding at least a four-figure sum. That is not an exaggeration to a number of cases. In the large ones, we're adding 5, sometimes high 5s. I wouldn't like to think about what this case has cost.
Is there any indication that the restructuring of paragraph 110 into the 2 gateways has led to an expansion of business, particularly the way
There's been
gateway
some pick-up, but there is a discernible difference in our submission and a recognised difference between saying, could the authority have decided this, and would a judge decide it differently? I'm mindful of what my Lord Mount said, but I don't think it is perceived that judges do, in practice, introduce, the line is that fine so that you can really work almost on a proposition. I apologise if I misparaphrase, but as if it would make no difference, you might as well go for it anyway. The financial cost I've talked about are high 5s. Once we get into appeals, then of course it's very considerable, and we get into a Salford situation, as in the recent cases, Salford and Mullen. Salford didn't take part. They wrote to the court and they said it wasn't. They supported an application for a stay made by Birmingham and Manchester, and supported by Secretary of State, but then didn't take part. In summary, because it wasn't cost effective, they couldn't afford it. And I do need to. Lord Mount's referred to large housing authorities. There are fewer and fewer of large ones. Some are so small they have none, yet they still have responsibilities for ASB. But many now have a small stock. And one of the points to make, it does need to be made, is that all this expenditure here, if one will, especially if it falls all to us, comes from the housing revenue account by law.
Well, even a large housing authority has better things to spend its money on than litigation, obviously.
Yeah, a smaller authority, though, often doesn't have the money to do it. Sometimes it's a choice between appeal this one and fight that one. And Lord, the point I wanted to get across is the money has to come from the housing revenue account, which means subsidy aside from rents, so the other tenants are paying. May not be willing to give evidence, but they don't have a choice about paying. Of course, it goes without saying that there's always someone else waiting for the property, there's the delay, but the other part of this is not only the cost. Once you get into delays, in most IT and DKT cases, introduction demoted, we're talking about some degree of antisocial behaviour, which the community then has to put up with during these delays. I accept they are not all big cases like the ones we've seen in the newspapers like Askew, Pilkington, which no one can forget, or New Love. But whatever process is adopted will of course have to apply in these sorts of cases as well.
Can I take you back to Salford's case? I mean, you obviously weren't involved, but the position was Salford decided not to be represented in the Court of Appeal.
And rely on everyone else, yeah.
I see. But
they wrote and they said...
And is that an indication that they're trying to avoid expense because of this?
Yes, in the current very difficult financial circumstances, this is what they wrote to the Court of Appeal.
I see.
It is not judged to be cost effective, assumes no order as to cost, if misjudged not to be advised, reserves its position so far as any hearing beyond is concerned, no disrespect intended, taken solely to save the expense of this litigation. This was an email sent to the Court of Appeal, and obviously disclosed to all the other parties. The Lord saying is that even low-level ASB is distressing and does mark an area. Much of it is, of course, not like the huge cases. In the present case, yes, there is a murder in the background, which is Trevor, the oldest son, but he's in jail for a long time. And I also agree with the proposition, I think it was Lord Roger, that we would have had to prove it all once on the demotion order. But can I remind the Lordships, look how difficult that was. We had no direct evidence. No one would give evidence. No one from the community. Those who gave evidence did so supportively of the Pinnocks, talking about what sweet children the boys were. Yet, I'm not going to go to it. Can I just give you the four bundle references? Pages 198 to 206 is the amended particulars of claim, and they set out the incidents we allege. Some of those were not determined by the recorder because he took the view that if ASBOs or ASBIs had been made on the back of them, he should just accept that they had happened. Others he went through, and you will have read that, or may have read that. And then, of course, after that, we then get the three incidents during the demotion period. And at page 305 to 307 is the recorder's summary, but that is without any details or any facts, which is why I am referring to 198 to 206. There may be some minor dispute, but broadly it's an accurate picture. Yet, as I say, the direct evidence was simply people saying what nice kids they were. We cannot get the evidence. It's difficult enough once to get the demotion order on the basis of second-hand evidence from officers of the police. But if we then have to do it again at the review panel, and if this jurisdiction is opened up, we may well have to do it again at the county court on the possession order. And actually, we're in a much worse position than the suspended or postponed possession order. That may make it attractive. It may suggest that the provisions ought to be repealed, and maybe if there's a declaration, that is what will happen. But respectfully, it's not for this court to cause a repeal. It's to declare it incompatible and for the government to address it and address the implications.
I thought you'd accepted the review panel had to consider proportionality.
Now, I explicitly reserve the position on section 6.2b, my lord, and I'm coming to that very shortly when I finish up here. It's my next heading, so if I may. But we certainly say they have to act fairly and responsibly in domestic public law, which is why I say there would have to be proceedings before them. We know there have to be proceedings. What I'm saying is, first the demotion order, then the review, then a third bite of the cheque. And all I was saying was that actually we would be better off with going for a suspended possession order than on breach going back. I may say this is very poor legislation. I can't imagine many authorities are encouraged by this case to take it up, but there we have it. And I am going to come shortly to just slightly the wider statutory position on antisocial behaviour. But what I was trying to say at this point in finishing up here is that it gets harder, because if you get there once and all you get is a demotion order and they're still there, it's actually harder to get people to prove more, because there is a sense of getting away with it, because all people do really respond to is either or. They're gone or they're not. Mr. Drabble has repeatedly emphasised, and rightly I think criticised for doing so, how innocent his client is, because he's never been accused of anything, although his partner had an injunction made against her, an order made against her. And it's really, it goes a bit far to brush aside the father's responsibility. The recorder said he'd been rather ineffectual. It may be thought that with 5 sons all having convictions, many of them involving prison sentences, that's a little bit of an understatement. But there we have it. Not one of the sons has ever given evidence suggesting any willingness to reform. I'm closing up at this point. My Lady Hale asked for an up-to-date statement to be agreed. I'll be frank and say we've not even tried to agree it. I think we agreed that we would put our own statements in, because it would be a very difficult exercise, especially going on during this hearing. So no disrespect, but I hope you accept that. we will, I'm sure Mr. Drabble will, we will also put in a statement. We have inquiry difficulties. The officer in question is on maternity leave, her replacement is here, and so on. So I apologise for that. But it is important, Mr. Drabble has been making this point, that the acts do go on. Arain has been convicted of drink driving offences.
We're on issue 7 now, are we? The specific to the proceeding.
No, I'm dealing with it here because I suspect I will never get much to that, and it will all be in writing. So I want to get this out of the way rather than...
So this is issue 2, incorporating issue 7, effectively.
A little bit, yes, my lord, but I'm really responding. It's the result, direct result of the inquiries we made at Lady Hale's request, or implied request. Orion, convicted of two further robbery attempts in the area and aggravated burglary, certainly in the locality. Yeah, this is from the police, we're not making it up.
I do object to this. I have no prior warning of this at all. The case has a history, let me make it absolutely clear, as found by the county court judge, of over-egged allegations being made, which have been put to one side. And our information is that none of the sons are living in the premises at all and have not been for some time. So I do object to having to deal with allegations which I had no chance of checking, made halfway through the oral hearing.
It may be my fault. I was looking at paragraph 1.24 of the Statement of Facts and Issues. There is a reference to Orion having been sentenced to 2 years' detention in respect to burglary. I'm not sure whether that's what's being referred to. If it is, it's an agreed fact.
That's agreed.
Yes.
That's the basis on which the judge made the possession order.
Yes, that's what I understand.
But I don't think my learned friend is referring to that. He's saying that there's an ongoing pattern which I don't accept. Actually.
Well, as I say, these statements will have to go in, and it will not be agreed. It's true that some of them aren't. Perhaps none of them now are living in the premises. Clive is also back in prison, but he, directly contrary to what Mr. Drabble was implying about them moving on and so on, living with girlfriends, he has given this address for his release date.
Speaking for myself, I don't see why we should be involved in facts that have occurred since the possession order was made.
My lord,
I don't understand
that may well be right, but we were asked to look at this because of the possibility of a proportionality determination, at least to wonder whether it was worth remitting by my Lady Hale. That may well be right. Normally we wouldn't go beyond it, but Mr. Drabble has made some observations about effectiveness. We've dealt with them, we've responded to them, and so on. And it's a considerable exaggeration to say that we've made over-egged, that the judge has found over-egged. What he said was he thought we were overzealous. And that is precisely in our enforcement of antisocial behaviour policies that we have all read about over the years. I'm not saying now, and I'm not saying Pinnock, but the position in Manchester was quite dire at one stage in terms of gun crime, and the authority took a particular policy and approach. And to a large extent, they've had quite a good effect in some of it, not enough.
As a matter of logic, if this is a continuing duty on the part of the local authority, of the public authority, to update its attitude to proportionality, that continued up until the decision before His Honour Judge Holman. And it's a bit difficult to see why it wouldn't continue at the appellate levels as well. We're considering the same question.
Well,
Yes.
I agree with that.
And so,
This is part of the difficulty we confront. If the statutory scheme is bypassed, it becomes Very, very difficult indeed.
Well, I suppose it's enough to say that questions are raised. I mean, we can't, we can't, as it were, accept facts at this stage. But if the position is, that you say questions are raised which are directed to the issue of proportionality, as in regard to events that have happened since, I think I can see the point without getting into great detail.
Yes, I agree. But if I'd said matters have been raised and said nothing further, I would have been jumped on for implying instead of it being explicit. All I'm saying is there are issues. It was a direct response. We hadn't made inquiries or intended to do so, but I'm leaving it there. I'm making the point about how difficult it is. Not to say virtually impossible ever to bring anything to an end. I want to finish with Mr. Luber's reference in his printed case to the Civil Justice Council's proposed protocol, where we would set out reasons, invite a response, respond to that. We are not troubled by giving brief reasons. We're not troubled by considering tenants' responses. Our position on domestic public law goes quite a lot further. We say you do have to consider anything that they put to you, and that there is no, that may be relevant in any event, you cannot ignore them. But in the main cases with which we're concerned, and I am concerned that the court should focus on these two cases, demoted and introductories, the protocol does nothing that hasn't been done. We've done the demolition hearing, we've given reasons, and so on. And we've gone through a review process if asked for. So it doesn't actually affect anything, it doesn't solve anything. It's when, having determined that we're still going to proceed, we're confronted with a trial date, we get into difficulty and cost and delay and so on. And a judicial determination of the eviction decision is the authority who have to manage, often with a very small stop. What discussion of the protocol does do is affirm what we're saying, that arguments will be raised, indeed that the invitation to raise the argument is being institutionalised. And once raised, it is easy to move into trial. I'm going to move now to my third heading, which is probably...
Just before you do, could you tell me, has there been any official survey, report, review of how the changes made in 2003, how the introduction of demoted tenancies is working? I see we have a number of official reports in volume 2014 of the authorities, but none of them seems to have anything to do with demoted tenancies.
I'm not aware of any that have been published. Mr. Stillitz is not aware of any, and that's where it would come from.
Thank you.
From the department. I'm moving on to the next head, if I may, which is sections 3, 2, 3, 4. I'm sorry, section 3 or section 6 or 7. 3, 6 and 7. Again, and I'm very conscious of time, I'm going to try and take this pretty much at a trot and rely on being slowed up. not to say barriers put in my way and fall over them as we go along. There's a well-recognised relationship between 3 and 6. Lord Hope in Hooper at 80 referred to them as different sides of the same coin. I think we actually need to go to it to see those words. And I want to leave aside for the moment the issue of whether section 6.2b means that authorities do not even have to consider convention rights in this process. I will come back to it, my lord. I'm not going to duck it, but I've got it in its, as it were, as its place in the notes. Our submissions here are straightforward. There is no way of reading or giving effect to the specific statutory provisions in issue here which is not legislating. 143D2 is quite clear. The court must make an order unless it thinks that the procedure has not been followed. The same is true in relation to introductory tenancies. See 1996, section 1272. The court shall make an order. In other cases, it may not be the statute which mandates that the possession order is made, but the common law. Nonetheless, Parliament has legislated in terms that adopts the common law, at least in principle, and that is Doherty. And perhaps we should have Doherty out for this part of our submissions, which is Bundle 4, tab 33, as I imagine everybody knows by now. At 30, I'm sorry.
433.
Yeah.
Which paragraph?
We're going to dock here.
Lord, yes. Fairly briefly, I was going to start at 38. I'm dealing with the point of the absorption or the Parliament taking on board the common law. Point made by Lord Hope at 38. Mr. Luber and Mr. Sales submitted Section 62B did not apply because the effects of the statute was the protections were available to others did not extend. The court was simply applying the common law. That would simply also apply, of course, Section 3. What we have here is a scheme that's been laid down by statute, the effect of which is to provide protection in some cases, which in others is not available. And paragraph 40, where he refers in the middle of it, where Lord Hope refers in the middle of it, it was just below D. It was exercising its powers of management when it decided to terminate its troops. It was making use of the method of the common law, but this was because the statutory scheme permitted him to do so. And finally, at 48, at the very end on page 409, starts and over the page, the unqualified right to recover is the product of the common law, part of the regulatory framework created by Parliament. My Lord Walker said made similar observations at 100 and 104. In the middle of 100, in the middle of page 430, just below F, common law, landlords entitled to that extent, first defendant, Secretary of State, correct in saying seeking possession relying on a common law right. Part of the picture, far from the whole picture, the unrealistic, productive error not to look at the whole. Common law right was surrounded all sides by statutory infrastructure like a patch of grass in the middle of a motorway junction, and then quotes Lady Hale, much trampled over by the legislature. At 104, a passage I referred to in opening, paramount consideration, I think, will be whether the composite legal scheme in general, the offending provision in particular, clearly represents the considered intention of Parliament. What we are submitting is that the structure of the Act, that's the Human Rights Act, is such that you cannot develop the common law so as to do an end run around Parliament's wishes, as expressed in or by primary legislation, and we rely, as we have done repeatedly, sections 3.2b, 4.6 and 6.2, not affecting the validity, continuing operation in the first two, and acting so as to give effect to enforce in 6.2b. And in Doherty, going back, if I may, to Lord Hope at 49, drawing it into section 3, provides that so far as possible must be read and given effect. The exclusions from protection that we found in these statutes are not susceptible to interpretation in a way that would remove the incompatibility. Giving effect to them is unavoidable. The court cannot make an order postponing the operation or suspending the execution of eviction order that be contrary to section 4.6 of the 68 Act as it stood at the time. As has often been said, skipping a line, Section 3.1 provides the court with powerful tools to enable it to interpret legislation and give effect to it. It does not enable the court to change the substance from one where it says one thing to one that says the opposite. And Lord Mance at 132 makes similar points. Talking about the submissions, the exclusions in the statutory regime are unequivocal and cannot be reinterpreted or qualified under Section 3. Exclusions make clear that the court's duty is to give effect to common law entitlement which would exist apart from the 1983 and 1968 Acts. In my view, subject to whatever may be the effect, Gateway B precluded the court from acting differently. Under 62A, and I possibly, sorry to keep going backwards and forwards, at paragraph 70, Lord Hope draws.
Paragraph 70. That's not Lord Scott.
I'm sorry, it is Lord Scott, but I'm not sure that I've got the right paragraph. If it's, well, I think it is a passage from your Lordship, but it has got changed, and it is probably not worth spending time going back to it. There's a point really where your Lordship just refers to sections 3.2b and c, making clear the validity continuation.
Thank you.
Unaffected. One of those where the removal is prevented by primary legislation, unaffected by the Act. It cannot be read and given effect. It doesn't merit the time. The only other passage I was going to refer to at this stage was going back to, I'm sorry, the 70 was in Hooper. I got confused. Apologise. And going back to K, which is at
I'm sorry, could you just tell me what proposition it is that you're citing these cases for, why we're looking at them?
because we are saying that you simply cannot read or give effect to this legislation compatibly on the assumption, of course, as I'm making, that there needs to be a proportionality hearing.
But before we get to these authorities, insofar as they're relevant, that's the issue. Mr. Drabble says it must be right that you can only, that the court must make the order, but only if it's satisfied that the procedures have been lawfully followed.
Yeah.
But lawfully followed includes giving Article 8 consideration to the Article 8 rights, if I can put it in shorthand, of the occupier.
Not if 62B applies.
Why can't they be? Why wouldn't the review procedure have to take them into account? Why wouldn't the decision of the decision of the local authority would have to take them into account, or not?
We don't say they don't have to take them into account, but they cannot be faulted for taking, if there is a difference, a disproportionate decision if it is under 62B. And we say that because we do not accept the interpretation of 62B.
Yeah, wait a minute. Just go back. I'm not quite clear what you say about the council. You've got a demoted tenancy. The council decides to take proceedings for possession.
Correct.
In taking that decision, do they have to take into account the Article 8 rights, if I can put it in shorthand, of the occupier?
They do not have to reach a proportionate decision.
Do they have to take that into account?
Yes, we accept they do take it into account.
I see, they can take it into account, but they can say to themselves, this is disproportionate,
Yeah.
fine, that's what we're going to do. Is that the argument?
Yes, because the needs of the scheme are there.
Well, yes, but is that disproportionate, or is that simply taking a view that they're outweighed by the needs of the scheme?
Well, this one of the difficulties is we've said all along that we see no difference between proportionality and Wednesday reasonableness.
Well,
there's a perversity. It is that difficult that we have meeting these arguments. But as far as we submit it, the position is that 62B clearly applies to this scheme.
You're saying to the sort of 62B applies to when the council's making the decision or whether the court's making the decision?
When the council is. It has no option of not acting, of abandoning the demoted tenancy scheme, of never using it. Be completely unlawful.
No, that's not the question. The question's a narrower one, I think, with respect. It's when deciding whether to bring possession proceedings against a demoted tenant, does the council have to take into account, or housing authority have to take into account, the Article 8 rights, if I can put it in shorthand, of the occupier? And I think you're saying yes, they do.
They take it into account.
Yes, and if they take it into account in a way which is wrong in law, then the decision is not arrived at lawfully.
I agree with that.
So the court has to carry out a review to see if it's carried out lawfully.
Well,
because if it hasn't, then the court has a gateway, indeed shouldn't make an order for possession, should it?
Well, there's a forum issue.
Let's bypass that for the moment.
Bypass the forum issue. If there is a challenge that we have failed to take it into account,
take it properly into account.
all right, take it properly into account. Yes. We've always accepted domestic public law. Yes. We accept that domestic public law requires us to consider.
So the only difference, you say, between what Strasbourg requires on the assumption you're wrong on the principal, on the initial point, and what the Act permits the court to do, is that Strasbourg says the court has to carry out its own exercise, whereas the Act only allows the court to carry out, if I can use Lord Staines's expression, an intense focus, Wednesbury exercise, considering the council's local. And that is the narrow way in which, if you're wrong on the main point, the Act does not comply with what Strasbourg said.
Yes.
Thank you.
Can I be quite clear, Mr. Arden, what provision you say the local authority is giving effect to?
Certainly.
Because we need to understand that if we're to understand whether Section 62B has any application at all. What is the provision?
It starts with Section 21. Mm-hmm. Well, actually, no. Can we start at... Where is it? Tab? It's going to be tab... Bundle 2, tab 12.
11.
Crime and Disorder Act?
Yes. We have an obligation to maintain, to have a strategy. And Section 5...
Which act are we looking at?
Crime and Disorder Act.
Crime and Disorder Act.
Tab
12.
12 in Volume 2.
Yeah.
One after the
We are an authority responsible for antisocial behaviour strategies, which are defined in Section 6.
Yeah.
6.1 is really sort of critical. And under Section 17, we're under a duty to consider crime and disorder implications. And 17.1, the need to do all we reasonably can to prevent crime and disorder in our area, and that's exercising all our functions.
Well, at the moment, these are so broadly expressed that I can't see there's any problem about giving effect to convention rights.
No.
So they're broad enough to allow you to take convention rights into account.
Well, what I'm saying is the parliamentary scheme starts with that in a sense,
right.
Or our duties do. We clearly can't abandon any of the tools in connection with it. The next...
It seems to me that none of this is going to be in dispute between you and Mr. Drubble, that you have to take into account.
That may be right, Lord.
Including Article 8. I mean, that's not in dispute.
No, but if we do so, we have a lawful decision. If we have a lawful decision, In our submission, section 62B applies to us, section 62A applies to the court, section 143D2 prevents there being any proportionality review. It's very circular, I think Lord Mann said at one point. You go around, if we reach a lawful decision, that's an end of the court's power. Depends where you get on or get off the roundabout.
But you have to have a continuing decision, and so as you appear in court saying, please make the eviction order, you accept, as I think you accept, that you are saying, because we say it is proportionate to make it.
We say it is proportionate for us to seek possession. We don't seek to say, and I think that means, on some analysis, that that's not compatible. We are saying, in our view, it is proportionate to seek the order. Once we say that, if that completes our duty, the court has no power to do anything other than make the order.
So just to see if I can get an answer to my question, the point of collision or potential collision comes, does it, when you're looking at section 143D2? Because is your position that the local authority is giving effect to that provision?
We're not giving effect to it.
I'm sorry?
Your Lordship asked me, and I was beginning to answer, the provisions I was relying on. It's the Crime and Disorder Act.
I see.
Section 21, plainly.
Quite so, yes.
Section 82A of the 85 Act, which Pinnock then took you to, and seeking a demotion order, and the power to evict, which we've now been given by the court proportionately.
To be found in?
It's in the scheme, one can call it Section 21, or in Part 3 of the Housing Act 1996. You need an express power to use it. You take those provisions, there is a clear parliamentary scheme for dealing with antisocial behaviour. That is the scheme we are giving effect to. In our submission, we would have thought that could not be clearer. But that is what we are doing. It's not a scheme of our devising. We, of course, can see the argument. I think I said this yesterday, that you can't simply say Section 21 is incompatible because it may be exercised sometimes it's far too wide. Can't use Section 21 to devise an incompatible scheme and then rely on it. But we're looking at a clear, cogent, parliamentary scheme for tackling a very major social problem called antisocial behaviour. Where in our respect, the submission shut the court's eyes to the fact that that is what we are doing.
So
any analysis of...
You said Part 3 of the Housing Act 1996, where...
I should have said Part 5.
Yes. And Section 21...
Part 2 of the 85 Act.
Yes.
Housing Act 1985.
Yes. Yes. So general management power, is that?
Yes.
Yes.
Well, as my Lord Walker rightly said a couple of days ago, it's much wider than evictions. He referred to drains, we would refer to play areas, parking rules, and so on and so forth.
Can I just clarify one other point? You gave Lord Newberger your bottom line, but just thinking ahead, if you're wrong about Section 62B, there's another bottom line, isn't there? You say that you still say it's your decision. If your decision is reviewable on Human Rights Convention grounds for proportionality, that is a broad review, and it doesn't enable the court to put itself in your place. In other words, the elision that I suggested doesn't exist. You've already made that. Am I right?
Yes, Lord.
Yes.
And Lord, I was going to go to K, continuing the point that the common law had been adopted into the legislation.
Yes. Sorry to take you back, Mr. Arden. I just want to be quite sure. I'm looking at section 143E of the Housing Act 1996, which is in bundle 2, tab 10, several pages in. 143E, is this the provision that you say you're giving effect to when you serve the notice which initiates the proceedings of possession?
This is chapter 1A is part of the scheme, yes, it starts.
Yes. And 143E is...
No, it doesn't start with this, but yes.
143E is the critical provision, in effect.
For possession,
Yeah.
yes. We're saying you can't look at section 21 on its own, and this is really our point about section 62B, that the provisions in issue can't be taken a very general scheme, but that if there is a clear scheme designed by Parliament, to which we are giving effect, then yes, we are exempt from section 6.1 if the legislation is incompatible. So I'm starting with the proposition that the legislation is incompatible. I was simply, perhaps I don't need to go back to K because we've referred to it before, which is the Housing Act 1980, section 89, which is also a limit on the court's jurisdiction. This is the 2 weeks to 6 weeks. True, it applies only when the court makes an order for possession. But at 202 in K, my Lord Brown does seem to treat that as sort of starting with the common law position, which is that you're entitled to possession. And what we are saying, we also refer in our printed case, it may be more convenient to deal with it there, at 120 and at 123. To the fact that there are parliamentary mechanisms for giving more direct effect. At 120, we point to the Nationality, Immigration and Asylum Act 2002, which disapplies certain benefits to certain asylum seekers, but then disapplies the disapplication to the extent it's necessary for persons' convention rights or persons' rights under community treaties. We're saying if Parliament has expressly addressed that there, it is not open to the court to simply read section 89 as if it said that, because in our submission, if legislation is what this is, then that clearly says it would be legislating to do it. I also refer, it would be very well known at 123 to the direct application provisions of the European Communities Act.
I'm terribly sorry. I mean, Mr. Ron, Parliament hasn't said once you've got a demoted tenancy, the authority, next time they put a foot wrong, has to seek possession. It said the local authority in those circumstances may. It's a discretion.
It is a discretion which we have to consider using.
Quite.
Therefore, we are giving effect to the scheme. We cannot say we will consider it and in every case never use it.
Of course you can't say
And we
that.
say on our submission as to section 62A, appreciate the submissions the learned friend has made of the ambit of section 62A, but we think that left out, 62B, I'm so sorry, left out of account the effect of section 143D2. But we say on section 62A that we are clearly giving effect to a scheme.
You're getting muddled up, I'm sorry. 62A...
2B, I'm so
yes,
sorry.
62A is quite explicit. It's the authority could not have acted differently. No, you're not saying that. You're not.
No, we're saying that the court can't act differently if we've reached lawful decision.
Lawful decision.
We accept that. We've said all along.
Yes, lawful in the public law, common
Yes,
law.
sure.
Yeah, sense.
And I'm leaving forum aside.
Yes.
We've never cavilled or asked for a right to make unlawful decisions. It has to be lawful, but once we've made it, the court has got no power to do anything else but make the order.
Yeah.
Going back to my Lord Brown, I'm sorry, that was a diversion because I misspoke and said 62A. Lord Hope was correcting me. 62B, the legislation prima facie is incompatible on the presumptions we have, because there is no provision for a judicial determination of proportionality. That is clearly what section 143D2 says. If that legislation is incompatible, it is that legislation which has to be read down or given effect compatibly. You cannot, in our respectful submission, use section 3 to give a jurisdiction to the county court. So the only question then becomes whether we are acting unlawfully. Our submission, we are not acting unlawfully if we go ahead without a county court, because we can't confer jurisdiction on the county court to make a proportionality decision. The jurisdiction we can give them, that order. If that legislation cannot be read compatibly, it has to be read, rewritten. It isn't a question of giving a different effect in each different case. That legislation cannot be given effect or read compatibly because of section 143D. Therefore, if we have made a lawful decision, the court cannot make a proportionality decision. We have to consider using the powers in every appropriate case. We have to consider, and in every case where there is an appropriate case for seeking possession, we have to do so. We can't abandon a power.
The 143D2 argument is a different argument from the section 62B argument, isn't it? I mean, the 143D2 argument is an argument that the statute, when it says the court must make an order for possession, is impliedly excluding the right of review on Human Rights Convention grounds of the local authorities' decision, because it would undermine the court's duty to make an order for possession. Whereas the section 62B argument is just an argument which it attacks the ability in a different way to review.
First of all, it's the scheme as a whole which has to be looked at. The effect of 143D2 is that in seeking possession, we will be seeking it without an independent proportionality hearing. And as I understand it, that makes it unlawful. But it's not unlawful if we're acting under 62B, because we're allowed to do so. Which is why I think, my Lord Mount yesterday said it certainly. And what I was doing coming into this was starting with section 3, because I think one has to start with section 3, because that's the first side of the coin. And I was referring to various passages, and I did want to give 2 more passages on which I do rely, in which it's been said that giving this sort of jurisdiction would amount to legislation. If it's convenient, I can just give the references, because they're very short. That would be Poplar Harker, Bundle 6, tab 52, and it's Lord Wolfe at 77. Says Mr. Luber says all is required is to insert the words if it's reasonable to do so. he would say the same as if it's proportionate and reasonable. The amendment may appear modest, but effects would be very wide indeed. It would involve legislating. I've referred to SMART so many times that I've been told I'm repeating myself, so I'll skip it. But there is also Michalak at 63. Sorry, Bundle 10, tab 95, at 63. Parliament has decided who succeeds. This is on the non-qualifying successors, if that is a clear enough description. Reality is Parliament has, in the provisions, considered and determined the extent to which those residing with a secure tenant should be entitled to succeed outside the categories others residing were not to succeed. Parliament necessarily contemplated dwelling house to come again. And we say that that is saying it will be legislating to do otherwise. The critical distinction is between those cases in which the court has a jurisdiction to decide whether or not a possession order gets made, those cases where the court has to accept that the contractual and statutory provision prevails. Parliament having decided that those cases are not such that the court should be the decision maker, the statute says that all lettings are secure except for introduction to motives. Thus, Parliament speaks. In my submission, it would not be right for the court to try to outflank Parliament by inventing a jurisdiction which Parliament has denied. Even if the court considered that it might have such a power, we would submit it would be wrong to do it. First, because it would be wrong to mould the common law to provide a remedy, which would be a very considerable matter, because that would have to mould the common law in its application to everyone. I don't think it could be argued that we could mould the common law so that the court had a power to defer possession in the case of a public authority, but not otherwise.
I simply don't follow that. I mean, you accept that you're a public authority, and as such, you owe a Section 6 duty to comply yourself with the Convention and with the requirement.
I don't if it's under 6.2b.
Your action isn't under 6.2b. 6.2b is dealing with what the court must or must not do.
No, 6.2b is dealing with a public authority.
Sorry, I beg your pardon. Yes, now-
6.2a is the court.
Yes, I said this time I did say 6.2b.
Yes, no, sorry, my fault.
But just because you've got a discretion, which is capable, obviously in some cases, in the great majority of cases, of being exercised to seek possession in one of these cases entirely harmoniously, consistently with the Strasbourg jurisprudence. But you don't have to if it's inconsistent, if it would in fact breach the Article 8 right of that particular occupant.
My Lord, on a very narrow reading of Section 6.2b, that is right. But on our reading, which is somewhat wider than that, but not as wide as that which I think Lord Hope's speech in Doherty has been taken to be, that is wrong.
Well, if you, I mean, well, all right, there's an issue, but if that's right, then because you're a public authority and because of Section 7.1b of the Act, the occupier is entitled in the eviction proceeding to say, put the argument on forum aside.
Yes, of course.
I'm complaining that my opponent here, the public authority landlord who's trying to evict me, has behaved contrary, or is proposing to, is still acting contrary to the Act. Will you, the court, kindly, in accordance with 7.1b, decide that issue? And then the court has to say, well, is the authority acting disproportionately or isn't it?
7.1b doesn't arise if we've acted lawfully.
Right.
It's not there.
The difference between you and Mr. Drabble is very, very slight. You accept that the court can not make an order for possession, if it said that your decision didn't properly take into account the Article 8 rights of the tenant?
Oh, yes.
He says the court can go, you say, and this is the difference between you, the court has to go one stage further, and he says can go one stage further, and form its own view, rather than revealing your view, of the Article 8
Yes.
rights. And that's the only difference between you.
I think I said
Subject
this
to the
almost
form.
when I stood up.
Exactly. I mean, that's the difference.
It is a small difference, but in our respectful submission, it's an important difference.
Well, I see that.
A very important difference.
And if
Sorry,
you...
does this only arise if you're wrong about Section 6.2b, though?
No, I don't think it does.
I thought that Section 6.2b would exclude any review by the court of your decision.
No, I've never suggested that.
So it's very... And given Lord Staines's intense focus on your case, the difference between you and Mr. Drabble is really pretty slight in practice.
Lord, we do think it's small. I hoped I made that clear when I got up.
I'm not saying you didn't. I'm just clarifying my own mind. Thank you.
6.2b does allow us, in our submission, to reach a disproportionate decision. What the court considers to be. It goes further. It allows us to do so. If there is a difference, we have to take it into account.
That's the point. If you reach a disproportionate decision that's wrong in law, the court can set it aside.
Yeah, but it's not wrong.
If you reach one that the court doesn't agree with, but isn't disproportionate, then the court can't.
I don't think it's quite the sole distinction.
No.
It's not
I don't think we're quite understanding you at this side.
I'm so sorry.
Because you say the local authority has to take proportionality into account, or Article 8 into account, but you also say that the local authority is permitted deliberately to act disproportionately. Now, that is a big difference from Mr. Drabble. The narrow difference is the nature of the court's assessment. You say all the court can do is ask whether the local authority has acted lawfully, whereas Mr. Drabble, with some encouragement, went further than that. But it's a big difference for you to say the local authority is entitled, if it wishes, to act disproportionately.
Yes. But we do say that. We do say that if in order to give effect to the scheme, we do need to take a disproportionate decision, then that is permitted by Section 6.2b.
What do you mean by disproportionate? Because I think that's my...
Well, this is where the whole theoretical discussion loses focus, because as we've said all along, we don't really think there is a difference.
But no, I'm not asking that. I'm asking what do you mean by disproportionate?
Well, we have a decision where what we seek to achieve cannot be justified by the means we use.
Well, that's unlawful, isn't it?
Well, I agree.
And therefore the court would set it aside. I mean, I don't understand what you mean when you say you can reach a disproportionate conclusion.
If there is a difference, we don't think there is. We couldn't have been clearer.
Can I ask you whether an example might be, because it seems to me that it is a big difference. You say we've got to have a strategy for preventing antisocial behaviour and crime and disorder and so on and so forth. We have to use such steps as we have to do that. So part of that is to use the demoted tenancies scheme, and part of the demoted tenancies scheme is once you're on your last probationary period, we can decide that we want rid of you. And there's nothing in the statute to say that we've got to have any particularly good reason other than a Wednesbury reasonable reason for getting rid of you. And that may very well mean that we say, well, the Pinnock boys are still causing havoc in Longsight, and even if Mr. Pinnock Senior is at death's door and has lived there for 30 years, we want him out. That's what you say you can do.
Yes.
But you accept that in carrying out...
That's exactly what you say you can do, isn't it?
Yes.
Yeah, I'm not making any comment about whether you can or you can't. I'm just trying to clarify for everybody's sake what it is you are saying.
I said just yes, because it put it a lot better than I have managed to do so.
But you
how is that possible under Section 6.1?
But you do say in that thought process, you have to take into account the Article 8 rights of Mr. Pinnock.
Yes, we've taken them into account, but we've decided to override them.
You've decided that.
We've
Okay.
decided.
Yeah,
The greater good calls for it.
why is that disproportionate if you've taken them into account and considering that outweighed by other factors?
That gets back exactly to what we've said. The difficulty of this discussion in housing, we don't think there is a difference.
But if the court was to think that it was no reasonable authority to take the extreme, forgetting the intense focus, could have taken the view that his Article 8 rights should have been overborne by other considerations, then it's not a lawful decision.
Well, if the court would have to conclude on our submission that no reasonable authority could have decided to evict.
Well, that's what I said, yeah.
Well, your lordship put in considering Article 8.
Well, no, because Article 8 has to be taken into account.
It is very difficult. It is very difficult, my lord. The burghers of Manchester don't lie awake thinking about the distinction between perversity, intense scrutiny and proportionality.
I'm sorry, I still don't follow this. Just assume, for example, that completely irrespective of the family circumstances of the occupant, the council says we want to make an example of this so that other families on the estate know that they can't misbehave, and we are going to seek a possession order against this family. Now, you say, what do you say about the lawfulness of that decision?
Can I respond directly to that? Because it's a very good, if I may say so, Lord. It's a very good example. The court, having made a demotion order, the authority clearly could not act in domestic public law in a way that conflicted with or distorted or perverted that court order. So we couldn't say the next day a demotion order was made, you've no longer got security, ha ha. There have to be some grounds. But if the authority say, in our view, this trivial offence, or relatively trivial offence, I don't know, stealing from a sweet shop, whatever, that's enough. You've been given your last chance. We must show the community zero tolerance. That we would be allowed to do, even if a court might think that was disproportionate, even although we don't believe a court would do so, because the zero tolerance policy is rational and respectful.
Well, then what about Section 6.1 of the Act?
Oh. This, I think, was Lord Brown's approach in Hooper. And we think there's a lot in it that I think your lordship is saying, are we protected by that?
No. It is unlawful for a public authority.
I'm sorry,
not protected.
I'm so sorry. Because that does not apply if we are implementing a scheme.
If what?
It does not apply. 6.1 is disapplied.
Yes, your answer to what about Section 6.1 is 6.2b.
Yes, absolutely.
Where do you get 6.2? How do you get the statute, the relevant statute revisions, to get you home under 6.2b?
Well, I've just identified them as a parliamentary scheme.
I see.
It's Section 143E, which is the possession order which you serve, I think, the notice, rather, giving your reasons for seeking possession.
But 143D says the landlord may only bring a demoted tenancy into an end. So all it does is to give you that power. It doesn't say you have to.
No, but on our reading, we don't have to do it to come within 6.2b.
Well,
because otherwise, there's no distinction. I'm so sorry, there's no distinction in practice between 6.2a and 6.2b.
I mean, as I understood it, you draw a distinction between the court's position on your construction, where the word must is used. That's a 6.2a case, because the court has no alternative. That's a 6.2a thing. If there's a choice to be made, it isn't a 6.2a case. But you say that is a 6.2b case, provided you're giving effect to something which is
clearly identified parliamentary scheme.
You say, but that's giving a wide reading to B. I think
it's a less wide reading your lordship gave in Hooper, respectfully, or at least in Doherty, rather. Sorry, as it's been interpreted. But it's not that wide to 6.2b. If we go back to 6.2b, the legislation, at least or the legislation is, on its face, incompatible. Our deciding to use it does not give it. Our deciding to use it does not give it an independent hearing, proportionality hearing. We can't confer a jurisdiction on the court. We cannot give effect to it in a way that is compatible. The most we can do is think about it. But we say we are. To the extent that there is a difference, and we don't believe there is one, I keep saying it, it's very central, we are giving effect to it. It's on the plain words of 6.2b. It's not saying any discretion. But these provisions cannot be read in a way to be compatible or given an effect in a way that is compatible because they exclude a court hearing on our submission. That is the point. If therefore we reach a lawful decision on it, there's an end to it. You cannot have a proportionality hearing. Because nothing could be plainer than Parliament said the court shall make the order.
So the incompatibility is 134D2, is that right?
Yes, on this premise.
That's what makes the scheme as a whole incompatible. Yes. There's nothing incompatible, no problem about 143E or F as they stand. It's because they lead up to 134D2, is that right?
Yeah.
Mm-hmm. Yeah. The fact that the court can't itself make the call on proportionality.
Yes. And even if the court did, it wouldn't be ours.
It wouldn't be you.
Even if the court made a call, it wouldn't actually be, of its own, it wouldn't be a determination of what we'd decided.
Well, that's the same point in different places.
No, I mean, your whole case rests on a broad margin of difference between a local authority decision and a public authority, and a court decision.
The independent tribunal, that's the point, of using the words of Strasbourg.
Yes.
The independent tribunal is what, with respect, has clearly been cut out of the process by the creation of the demoted tenancy.
Quite.
Nothing could be clearer than that. The Parliament has deliberately decided to take it out.
So, because the court has no power to review the proportionality of the decision, implicitly, the decision doesn't have to be proportionate. Is that what
we would say explicitly? Actually, we would say explicitly by section 6.2b. I mean, that may be a quibble. I mean, I'm accepting what your lordship says, but I think it's actually explicit. 6.2b.
Mr. Arden, I'm beginning to think you accept that you, as a public authority, for your part, are required to act lawfully and indeed proportionately as you see it, proportionately, consistently.
No, I'm sorry. The Lady Hale did actually say it's precisely the difference. We might reach the view that this would not be considered proportionate, but if we considered it necessary for the community, it's Mr. Pinnock on his deathbed, as it were, was the example. And we say, and that is where the difference between myself and my friend does get larger.
So there are two problems. I mean, on your analysis, this legislation is incompatible in two different respects. One is that you say, on no view can it enable the court as an independent authority to reach a judgment on proportionality. So if we took the view that's what the Strasbourg jurisprudence requires, we would have to say that section 143D2 is incompatible. But the other is that even if the court can make a review of the proportionality, even if the court were to try to make a review of the proportionality of your decision, that would be excluded by section 6.2b. Isn't that right?
Well, yes, but only if the legislation is incompatible. What makes it incompatible It's the absence of power to make court order.
Yes, well, that's, I think, exactly what I was putting to you.
Well,
because the court cannot review it, inferentially, you don't have to do it.
Yes.
But what if you didn't, what if you said specifically, we're not even going to take account of the convention obligations? Could the court do anything?
Probably not.
So do you have to take account of them?
No. Yes. I think my earlier answer has been that would be unlawful in domestic terms. If you have to take account of the convention, you have to take account of it. In domestic public law, it's just another consideration. That is different from saying you have to apply it.
So, what does the court do if you've been if you have taken all the formal steps required by 143E and F? What does the court then do?
Make the order.
Even if you have expressly said we're not going to take account.
No, I just said.
If you have expressly said we're not going to take an account,
then it's not lawful.
What does the court do? What can the court do?
Well, we're into the forum issue there. With respect to the law, we're into the forum.
Yeah, well, you would say that the court then, in order to not to infringe 143D2, has to adjourn. Is that right?
Well, that's the forum issue. And
what are the two alternatives open to the court?
The alternatives are either it is read, as my Lord Newberry keeps saying, you can read in the word lawfully quite easily, and if that's right, then the court would refuse the order.
Well, if it can read in lawfully, why can't it read in the requirement to act proportionately?
Because we don't have to, 62B.
62B you base upon 143D2.
The absence of the court's power. Nothing could be clearer than that Parliament has said that the court shall not decide. That's our starting point. That is incompatible. If we are seeking to give effect to that scheme, we are going to be acting incompatibly because we're going to be seeking possession without there being an independent determination.
But if you read in implicitly the word lawfully to 143D2, you then change it. And therefore, the implication that you can act unlawfully goes. Because the court can review whether you've acted
We
lawfully.
do not have to apply proportionality.
I don't understand that.
We do not have to apply proportionality. We have to think about the convention right. We accept that. We do not have to do it because Parliament has created a scheme which is not compatible and which excuses us if we give effect to it. Now,
so that if
lawfully, I'm sorry.
No, carry on.
Lawfully, I have no problem with. And if it is unlawful, and it is unlawful in domestic law to fail to consider the convention, I have no problem with that. But where it gets to be an issue is when we say, for supervening reasons, even though we recognise this is going to breach Mr. Pinnock's convention rights, we're going to go ahead because of, we think, greater good, even though we can see the argument on disproportionality, we are entitled to do so by section 62B. Now, respectfully, that is precisely what this legislation intends.
So your lawfully that you imply only means lawfully under common law, not lawfully under the requirements of the Human Rights Act.
If it is lawful under domestic law,
but the Human Rights Act is
lawful.
The Human Rights Act is part of the domestic law now.
And the Human Rights Act requires you to act compatibly.
Yeah. Unless section 62B applies. Richard, you're this side of the bench, not that side yet.
And you're saying in effect that you used the word zero tolerance was used, which is the extreme example. It's plainly contrary to the Article 8 right, and yet in the interests of the wider community, you shrug your shoulders and say, well, we're simply going to exercise zero tolerance and we're going to proceed.
Yeah.
Now, you say that you're protected by 62B, as I understand it.
That's precisely
because the scheme you're saying the scheme allows you to do that. And we haven't reached yet Section 143 D2. It's just simply that the whole idea of the Crime and Disorder Act and everything else that's built around it is to try to inject some sort of order into the wider community. Is that it?
Lord, yes. But we know that in implementing the scheme, there will be no independent determination of proportionality. And that it is only that element which makes it incompatible, the legislation.
But it makes it incompatible at two possible different levels. One, if Section 62B applies, then there's simply no obligation on you as a public authority to do anything other than you did. And the scheme is, so to speak, totally incompatible then, because there's no possibility of a review by an independent authority at all. But at a different level, less severe incompatibility, if Section 62B doesn't apply, then the court can review the Human Rights Convention conduct of your client, but you stress the difference between reviewing the proportionality of somebody else's decision and making the decision yourself. But then the scheme's incompatible because there's still no independent authority making the decision.
Then we get into a discussion about the scope of Section 7.1.
If supposing that just probably very artificial, but supposing that after you've gone through 143E and 143F, at that moment, just before you embark upon your proceedings, into the county court, somebody goes off to the administrative court and seeks judicial review of your decision on the ground that it is incompatible. Now, you say that even though we've not got to the stage of 143D, because we haven't actually begun, 143D2 nonetheless precludes any reference to proportionality in judicial review proceedings of your decision at that stage.
Yes.
Is that your position?
Yes, it is.
Why doesn't it review any common law judicial review as well? I mean, it says the court must make an order for possession unless it thinks the procedure under sections 143E and F has not been followed. So you should just be looking on your analysis at those sections. And common law judicial review might have a small bearing, but it would only be the procedural aspect of those sections that was relevant.
I'm not sure I followed you.
Well, I mean, if the section has this mandatory effect, why doesn't it exclude everything except what is covered by the section wording?
Because nothing is exempt from domestic public law.
Well, then why do we treat the European Convention on Human Rights as such a special animal?
I've not said that we don't consider it. We do, but we are excluded from Section 6.1 by 6.2b.
Perhaps putting it the other way around. Why don't we treat it as something that isn't excluded, just like common law review?
Because 6.2b says we can. Where I struggle with this, and why I'm sure I'm not being clear, is because to me nothing could be clearer than that we are trying to give effect to a parliamentary scheme, and that the parliamentary scheme is plainly, on the given assumption, incompatible. If it's compatible, it becomes completely a pointless scheme.
Nothing in 143E or F on their face, as I understand you accept, which would suggest it's incompatible.
No, it is 143.
It's 143D2.
Yes, exactly.
That's right.
So that's where you...
That's the simple.
Well, I accept we have to have the incompatibility to get into Section 16. If we don't have the incompatibility, we don't have the problem.
But the trigger that you're pulling in order to bring the case into 143D2 is in 143E, isn't it? E and F.
Well,
and
you've got the
gun in your hand, you pull the trigger and off you go.
We're invoking a jurisdiction, a procedure. Yes, a trigger we are pulling. That's precisely what we are doing. And that's precisely where it's going. And it is precisely where Parliament intends it to go. and it's up to Parliament to decide whether or not it wishes to, as it were, confront by the route of a declaration whether it wishes to pursue it or not. But it is an issue, respectfully, of national importance, the question of antisocial behaviour, and a very, very difficult issue of policy. To be administered by authorities, hopefully without too much difficulty, and while the aim of it is not to deprive people of their human rights, Section 6.2b, properly read in our submission, does say those circumstances we're allowed to proceed, pending Parliament dealing with it. And that's the whole point. And it's the point not just of 6.2b, it's the point of 3.2b, and it's the point of 4.6, which is the preservation of incompatible legislation, which cannot be read or given effect, and this cannot be read or given effect because of the want of the court proceedings. What I haven't yet addressed is Section 7.1, and whether in any event that is not being stretched on any approach to this. Can I have one moment? So I was going to move on to that. I wanted to check with Mr. Manning whether there was anything I had left out at that point. Which is possibly just this, that if the proportionality jurisdiction is as Mr. Stillitz describes it, then it would still not be right for this court to read it, or as it were, write it for him, because that sort of jurisdiction, which is commonly found throughout Europe, actually in the EU, most states, I said this yesterday, do have some sort of long-stop jurisdiction, is still one which Parliament ought to consider, whether and where it applies. For example, issues of paying rent and so on and so forth, which are to be found in some of the domestic security legislation when you postpone an order for possession and so on. Well, there is a number of issues thrown up which Parliament ought to consider how to address in these cases. It's not an argument about tolerated trespass. Lord, that isn't actually a problem, because the 2008 Act amendments, if an order is refused, can simply keep the demoted tenancy alive. It's not a question of needing to go back to that, or needing to retrospectively invalidate a notice. There's no need to do so. Lord, on Section 7, remind your Lordships that that is essentially a procedural provision. It is not a mechanism for seeking to achieve compatibility. That is achieved, that is done by Section 3. And in saying that, we essentially rely, first of all, on essentially a mechanism for securing redress for a breach, and not about mechanisms for making domestic law compatible. It premises the illegality. In one sense, we say Section 7 says Section 6 is done and dusted. you can't read section 7.1 in to section 6. That doesn't make section 7.1 redundant. Obviously, it applies where someone does act, where compatible legislation is being used incompatibly. On the analysis that section 7.1 be used to achieve compatibility, we don't think stands for section 7.11, which is the rule-making power, allowing relief or remedies that tribunals may grant to be added to by the minister, or the grounds on which relief may be granted. It doesn't seem to us consistent with the Act to say, well, yes, this is compatible or not compatible by reference to section 7.1.
If you're wrong on 6.2b, is there then a conflict between section 7 and 143D2?
Yes, in any event.
There is a conflict, isn't there?
143D2 says you cannot exercise a particular power.
Says the court's got to go ahead and can't entertain the defence, but there's section 7.1 saying you've got a right. Which prevails?
Section 143D2, because that's the clear intention of Parliament. And section 7.1 is not a provision designed to achieve compatibility. It's a given that there is an illegality within a compatible provision or framework.
Well, wait a minute. If it's the court that has no option but to make an order for possession, then section 7 wouldn't apply in relation to the court. We're saying section 7, you're talking about section 7 raising the tenant's right against the court or against the housing authority.
I'm sorry, my lord, I couldn't quite...
Section 7, are you talking about it in relation to a public authority in the first line, being the court or the housing authority?
In relation to making orders, section 7 is... Well, section 7 covers both.
I know, but which are you talking about at the moment?
I'm saying that the court, as a public authority, cannot do other than...
Yes.
Make the order. Section 143D2.
So, I'm not sure I follow this, but you're accepting, are you, that the person can raise the issue, as it were, it's something that can be raised in the court, but the court has only one way to answer it.
Well, the court has no power to entertain it, no.
No power to entertain it at all, does it?
No. Because if 1A applies, the convention doesn't. Sorry, 2A.
It's not unlawful.
Sorry?
It won't be unlawful, and therefore there's no issue to raise under 7.
Oh, quite. Yeah.
But if it's your clients,
Quite.
the local authority seeking possession, if they are the public authority.
Right.
That's the difference.
Well, whether there are two public authorities.
I know.
That's the point. That's why I asked.
I mean, I quite agree. It may be impossible to suggest that section 7.1 comes into play here, can avail the occupier here in respect of the court as a public authority, but as the housing authority, I should have thought it, on the face of it, does come into play. Because what it's saying is, here is the occupier, you want to evict, the occupier says, you are a public authority trying to evict me, that's unlawful.
Quite.
Section 7.1b says that's something I'm entitled to raise, rely on before the evicting, prospectively evicting court, and that's what it gives the county court the jurisdiction.
Quite.
This is getting on to the forum argument.
Yes, I
which I really would
agree to.
invite the Lordships to allow me to address separately and discreetly the forum argument.
Quite.
Because it does merit a few minutes. It's not a long argument.
I absolutely understand that, but just assume, put the forum argument aside and assume that it's okay to deal with it in the county court.
Right, yes.
Well, then where's the problem?
Well, we go back into the whole section 62B and 62A. The authority is protected by 62B,
Quite.
the court by 62A.
Quite.
That's why I put the premise that you're wrong on the authority being protected by 62B. If you're wrong on that,
If I'm wrong,
then there's a conflict between 7.1b.
Yeah.
if I am wrong about 62B, so the authority must reach what the court considers on its own determination to be.
No, just assume that the public authority has a duty to comply with the with Article 8, and has breached that duty, and is seeking to dispossess in breach of that duty. 7.1b would say, well, the tenant is entitled to rely upon that breach by way of defence. But then you find 143D2 saying, but the court has got to make the order providing the procedure has been followed. So there is a conflict.
No, there isn't a conflict, because if your lordship, on your lordship's premise that we would be acting unlawfully, then it's unlawful in domestic law. We're not protected by section 62B on this analysis. Therefore, we would be acting unlawfully. Then, leaving forum aside, I hope we had accepted repeatedly, in our printed case and here, if we're acting unlawfully, someone can stop us. Now, that leaves forum aside.
I think you said at the beginning of this chapter that Section 7 is procedural. And so it doesn't say that the court must actually accept the argument. You see what I mean? I mean, it's saying that a person who claims, this is what he's claiming, that the authority, that's your client, has acted in breach of Section 6.1, may rely on that, may rely on the right in any legal proceedings. Now, he'll be met by you by an argument, no, you're not in breach of Section 6.1 because you're protected by Section 6.2b. So that's an issue the court will have to determine. And Section 7 doesn't tell you what the answer's got to be. It just says the point can be raised.
Yes, as Lord Justice Waller, I think we are trespassing into the forum issue, because the premise of Lord Phillips' question was that we were acting unlawfully. Once we're acting unlawfully, we accept that that can be raised, and it's purely a forum question.
By unlawfully, you mean in whatever sense,
Well,
either a common law or under the convention, if that applies?
I think Lord Phillips said, I've got to assume I'm wrong. It is not covered by 62B. We do have to act proportionately. Therefore, of course, it's a domestic illegality.
So
come what may.
Basically, you say that Section 7 is wholly irrelevant to your argument because it presupposes that there is a defence of unlawful conduct, which, on your case, there isn't. So there's no defence to raise. There's no defence to raise. So we don't get anywhere near Section 7.
No. Well, that's what we're saying. Section 7 can't save it. It's not what it's designed for. While we're on Section 7, maybe convenient, certainly if it changes the subject, it would be convenient to me. There was the whole issue, the Zahentner issue, which turns extensively on whether the court is also a public authority. In its function of making a possession order, and my Lord Neuberger will realise, although there is the distinction to be drawn between contractual rights and so on, under modern domestic housing law, for the most part, it's the court which determines the contracts anyway. This obviously goes, for us, it goes into the mix as to whether a declaration should be made. It's an important point, because if we are right that this ruling, the application of the Strasbourg cases, would also apply to private possession proceedings, then in our submission that goes very considerably into the balance of declaration or not. To say the least, it is a very considerable amount of legislation that would be rewritten, with very considerable economic effects. It's after all the introduction of the assured shorthand that has seen a considerable rise in the private sector to where it's now up at 13.5, which is quite a long way ahead of where it fell to, around 10, 11%. I say all this on the premise that your lordships should appreciate that there is an equivalent provision in the Housing Act 1988 that the court shall make an order if various notices have been served against an assured shorthold tenant, and that is to be found actually, it's not in the bundle, I'm afraid, it's section 21, but it is quoted in Poplar Harker, which is bundle 6, tab 52, at 4.
At paragraph 4.
Yeah. I'm not going to go back to the Hunt now, although I do make the point that there was questions were asked about whether De Palma was cited in it or in the later Russian case. Of course, De Palma itself was an admissibility decision. I understand that those really weren't cited. I just wanted to say that. So what I'm saying is the argument that it applies to the private sector domestically relies on a correct reading of section 7. The court is a public authority, see section 6.3, and it would be proposing to act contrary to the tenant's Art 8 rights on this analysis. This derives from section 7.1, which directly goes back to section 6.1, which takes in section 6.3. We think it's also supported by section 7.6, because that envisages an appeal against the court below on the basis of its failure to comply, and otherwise need to spell out that legal proceedings includes an appeal, and we think it's also supported by 9.1, which is addressing how one challenges a court decision and claims is incompatible. See also section 9.3. All of these are wholly unnecessary unless what is envisaged is that the court is itself a body which must directly apply the convention, unless, of course, it's saved by section 6.2. We'll come back to... no, I'm not coming back to section 7. What's the other thing?
What he's saying, I've given up trying to find what he's saying.
Can I have one moment?
I'm not sure they are now.
Tell Robert that he doesn't seem to understand what he's saying either, which is the instruction.
Now, Julia thinks that I may need to come back to one point of Lord Mance's, saying why we can't just read human rights, as it were, as part of domestic law, which in one sense, of course, it is. But the answer is because it is deliberately filtered through section 6.2.
Filtered through section 6.2.
Lord, I propose to move on to my next heading, if I may. I'm doing fine, not well. Article 6 of the demotion order. Mr. Dravell has not abandoned Article 6, but he didn't develop it. We don't think we've got anything significant to add to our printed case, which we've identified where that is. Of course, in our printed case, we were developing a point I think we've now touched on more than a little, which is the nature of the decision being an evaluative decision, which is why we say it is one that we need to retain. But I don't think that there's anything really, that the approach that Mr. Dravell urges really does seem to return the process to one of having grounds for possession, which is what the process is not. But we don't need to deal with any of that under that heading, save the second part of it, which is the demotion order itself. But Article 6 itself, not having been developed, there's no point in my repeating what we've said. The demotion order...
This is part 4 now, of your argument, is it? We're on...
Of our submission?
Yes.
Yes. We took it here because we thought there was a considerable overlap between the Article 6 contention and the contention of proportionality hearing is required by Article 8. And we've set out our argument of paragraphs 166 to 170. If perhaps your Lordships could now have our simplification, because we're going to try and get through quite a lot by reliance on it, as I intimated at the beginning. And in our submission, the Court of Appeal was absolutely correct to say, when considering the requirements of proportionality, the statutory scheme must be looked at as a whole. It's a two-stage process, and it is returning to some questions asked by my Lord Mance of, I think, Mr. Drabble. It is actually the second most drastic step. First of all, we didn't originally seek a possession order, we were trying to use the new legislation, but then when there were further offences, because the schedule of offences I referred to earlier doesn't include the later incidents during the demotion period, but the most drastic interference is, of course, the outright possession order. If both are sought together, the second most drastic order is the demotion order. The postponed possession order is third of this trio, because you've got the power to go back and have a judicial hearing, whereas the essence of the demotion order was to take that away. I think my Lord Newberry was saying this earlier. There is a conflict in our submission between saying, unless at any rate it is totally confined to new developments, there's a conflict between saying we're looking at proportionality again. There's a degree of conflict altogether, because what the order was saying was you're not going to get another proportionality hearing. You're not going to get another reasonableness hearing. And insofar as they are virtually synonymous, you're not going to get another one. It flies in the face of the scheme, deprives it of its principal purpose, and is somewhat contradictory. In our submission, there's nothing in the Strasbourg jurisprudence to require such a conclusion. We make the point at 170. It would likewise apply to the issue of a warrant for possession. A conclusion rejected by the Court of Appeal. There's nothing in the dicta that makes it worth going to St. Bryce. And in terms of Human Rights Act arguments, I think Brown and Lord Hope used the word archaeology. It's getting pretty elderly. Strasbourg doesn't say anything about when the proportionality decision must be taken. It may be assumed that it would have to be reasonably proximate. So we do not see or read anything in the Strasbourg jurisdiction that says there has to be an independent determination again and again. No reason why determination having been made that it is proportionate to take away your security and your right to a proportionality here, that will govern a certain period. Agreed, it couldn't be forever. Although I think that's all I wanted to say under that heading. I move on to issue my fifth heading, the domestic judicial review, scope, form, powers of accounting for it. There have been very few submissions on scope itself, possibly partly because of what we've said. We've known if abandoned the introduction of proportionality, and we explicitly said in our Pinnock case that we think that the courts have been using quite rigorous scrutiny of local authority eviction decisions.
Can we just come back, I'm sorry, very briefly to St Brice? I mean, it's completely irrelevant, isn't it? I was just checking before I made the point, but the reasoning of the court was that it was an administrative act, the warrant of possession. It's completely different from the judicial act, where the judge has to make an order for possession under 142D.
It's still a public authority acting.
Yes, but it's
acting to evict.
The complaint is that there was issue without notice to him,
Yes.
and so he couldn't make representations. But, I mean, presumably, it was issued because he'd failed to comply with the terms as to payment made under a suspended possession order. So presumably if he'd said, well, I have paid, he could have gone to court.
He could have, if he had paid, yes.
Yes, so I mean the only issue was whether he paid or not, and that doesn't seem to have been disputed. So he had no right to any further judicial determination of anything.
Well,
he apparently wanted, I imagine, wanted to make open representations.
If there was a lengthy delay, as there commonly is between order and execution of warrant, that warrant is being executed by a public authority. Seems to us the logic of the arguments which have been advanced here, that there's an entitlement to another proportionality decision. I agree that if you have a reasonably proximate eviction, it would be viewed, certainly by Strasbourg, as administrative execution of the proportionate order. But what we are saying, and we're drawing the analogy, saying that we have here had a decision that it is reasonable for you to lose your rights to that sort of determination, and that 1 year is not such a lengthy period. I don't know if I'm causing that.
I mean, does this contemplate some distinction between demoted and introductory tenancies?
Well, we've already made I accept that, but that is why we say...
Nothing to accept, it was a question.
It does raise a difference because there's been no prior demotion order. But it is not only... does not have to be proportionate, it does not even have to be there does not even have to be a home provided. This is why we say that we, in our submission, are going beyond. This is not to do the argument that it's not a home because of its legal status. This is to do with the nature of the right, not in domestic law, but in any kind of law. It was a qualified offer. This is why we say we don't think Strasbourg goes that far. And we say the same in relation to the demotion order. It doesn't go so far as to say there has to be one, then another.
What you're really saying is echoing Lord Justice Ricks in Southwark and St Brice. Strasbourg doesn't require Article 8 factors to be taken into account at every stage. They're taken into account when the court says it's reasonable to make a demolition order. And the order for possession, which may follow under Section 143, doesn't require a further consideration of those Article 8 rights, at least by the court, and having been considered at the earlier stage. And to that extent, it's like the execution of a delayed warrant of possession.
Yeah.
Yes, I see.
The analogy.
Thank you.
How long would a delay was?
Sorry?
How long would a delay was?
Over a year.
Over a year.
Can I then move on to scope,
2.5 years.
forum and powers of the county court, because they are quite relevant and
I mean,
important.
you can pray in aid. I'm sorry to press this, but I'm quite interested in this analogy. It's 2.5 years between the order for possession and the warrant in St Brice, isn't it?
That's what I said, they could be very extensive.
Well, I mean, on the facts,
Yeah.
given that there was no Article 8 point according to the Court of Appeal in 3 recent judgments, you can rely on that.
Yeah.
Whereas here, you've got no more than a year on the demoted tenancy procedure.
After a proportionate decision on demoted tenancy. The question of the court not being aware of its effect. So,
I was wondering whether I could ask a question through you to inform my mind about this particular procedure. I mean, does in the example of the delayed warrant for possession, does the court have any function in the execution of that warrant after the period of delay? It doesn't go before the court again. Is that right? The warrant is simply in the hands of the party who's obtained it, and can then.
if it's executed within a year, I think, is that still the law? Yeah?
So it requires no
After a year, you need permission to issue. Is that right?
No, I think that you can apply for certainly in the procedure in St Brice, they applied for the warrant. There should be notice given to the tenant. The tenant does have the opportunity to apply to set aside the warrant.
I see.
And that was a complaint in that case. He wasn't given that opportunity. So the tenant can bring it before the court.
Yes.
But the landlord's not normally obliged to.
No, you do have to apply for the warrant.
You have to apply, but it's an administrative act. It doesn't go before. The judge doesn't decide whether to issue a warrant. It goes to the court office, and the court office, on the certificate of the landlord that the rent, the terms of suspension haven't been complied with, will issue a warrant. The tenant should be given notice of it, so the tenant can go to court and say whatever he wants to say about setting aside the warrant, and that's how it's intended to work. Is that right? I think that's right, isn't it?
I think that's right. Yeah. I think the tenant can be invoked in the Section 85 jurisdiction. The further postponement, what I said earlier. Lord, moving on to my fifth heading, which is quite important here. We set out our perspective on the scope of domestic judicial review at some length, partly because there hadn't really been much consideration of it in the earlier cases, and we felt it was quite important to emphasise how very small is the area between domestic judicial review and a proportionality merits hearing, which we respectfully don't think that Strasbourg has seen, is how Strasbourg has seen domestic judicial review. Particularly, none of the cases suggest that Strasbourg is aware of the extent of, can I call it, the fact jurisdiction, the Tameside type of jurisdiction, and nor is it clear that it's aware of the personal circumstances jurisdiction as set out at 43 to 53 of our printed case. I think I've already made the point that we may well sound as if we're going further than the big administrative law books would say, but they're predominantly dealing with the relationship between government and individual. It's a much closer relationship, and as such a more focused through a lens at that level, which causes all these personal issues to come to the fore. We certainly are comfortable with the proposition that an authority cannot turn a blind eye to personal circumstances. We've given the example of the redevelopment area where it might be overridden but we are comfortable with the proposition that you cannot ignore personal circumstances, you cannot shut your eye to it, even if you don't have to look into it, if it is raised. If the tenant comes and says, but, then someone with a decision-making power has to at least consider it before saying they make no difference. Issue 9 raises proportionality and enhanced security, and that isn't really being put. We said no substantial difference between irrationality and proportionality at R53. It sort of follows from that, no difference with enhanced scrutiny, because it's sort of between them. We can't think of a lawful decision of a local authority, looking at all the cases, a lawful decision which would have been held to be disproportionate. And when Mr. Luber cites cases of 13 of his case, saying that it is necessary to have a further jurisdiction, the answer is that domestic public law has been perfectly capable of catching errors. What is striking, there's much more time, is how very few examples there are over the years of harsh evictions that one would think might be held to be in breach, going back many years. Our central point is that it's difficult, to the point of impossible, to think of examples that would be different. But even if one goes to an enhanced scrutiny, that doesn't mean stepping into the shoes of the decision-maker, of course. That's Lord Daly in Stane and Lord Slynn in Alconbury at 52. We don't understand the logic or the principle of Mr. Stillett's 49, that somehow it's for the authority to determine the facts, but for the court to determine the personal circumstances. We really don't see that. And most of our submissions really under that head went to a plea for a simple, straightforward standard, and the difficulties local authorities have of applying some of
so they went to a simple, straightforward standard. I didn't hear what you said.
I'm sorry, my Lord, my voice did drop, I apologise. Instead of the more complicated or sophisticated approaches, which local authorities have very great difficulty in applying, particularly through the body of resources they now have available to them. Thus, we join with the Commission. I don't think anyone, I'm sure Lord Hope wouldn't have set out to have written so long and so much, and with so many ins and outs, and so on and so forth. We share the Commission's view, everybody, nobody possibly think that this is an ideal approach. But it is right to say, and the point we were trying to make, is that the idea of the Human Rights Act was to build it into administration, not to draw administration into law. This is over-judicialisation, in a sense. And we are looking for, and it may be that even if we lose on everything, it might still be the major gain, something more straightforward to be applied that doesn't involve so much law, and if I may say so with no disrespect, so many visits to the top court in the land in an area of administration like ours. I'm sure that would equally be welcomed by that court. We've likewise made our submissions on forum in writing.
Can I, I'm sorry to come back. I've been looking at St Bryce, and on reflection, I think it's rather against you, and it's quite interesting what's said. I'm sorry to go back. It's tab 90, bundle 10, tab 90. I'm sorry about this. I haven't looked at it, I'm afraid, before. But it was a case where the argument was that the landlord got an order for possession suspended provided the tenant paid the rent. The tenant didn't pay the rent, and 2.5 years later the landlord applied for a warrant. The tenant was served with notice and he didn't apply to the court. And the argument was it was contrary to Article 8 because the tenant's right to a home were involved, respect for his home were involved, and he shouldn't have had cast onto him the obligation to apply to the court. And if we just go to what Lord Justice Chadwick said, I'm sorry about this, at paragraph 35, opposite letter E, on page 1549, he says this in the paragraph beginning, in sentence, in the line beginning with brackets, with the assistance I think benefit he could afford. If there had been a relevant change in the tenant circumstances since those orders were made, Parliament had provided the opportunity through Section 85 for the court to consider the question whether eviction remained the appropriate response to that need. So in other words, he said that Article 8 was effectively complied with because the tenant could apply to the court. Yes. And Lord Justice Ricks in the next page makes the same point. Yes. So even in a case where you get an order for possession, the court seems to suggest, and Lord Justice Ricks makes the same point towards the bottom of the next page, that it's right that the tenant should have the opportunity to raise the question of effectively his Article 8 right. The point is completely clear in Lord Justice Ricks's judgment. So between a possession order where everything's considered and the execution of a warrant, the tenant should have the right. Might be said against you a fortiori, if Parliament thinks it's right that the tenancy continues and the court should make an order for possession, the tenant should have the right, in exceptional cases, if Article 8 factors have come into existence since the demotion order, of raising that point in the same way.
Well, Lord, it will be said, and
well, I'm putting it to you.
It has just been said. And that's right, my Lord, that is the implication.
Well, that's it said in terms. And
that is what it said in St. Bryce. In our submission, the European cases do not go that far. To the contrary, the European cases have tended to... I'm sorry, I want to be very sure. The European cases on execution. If there were they were Article 6 cases, I'm actually...
Yes, because Article 6 was in play there, but it was mainly Article 8.
Yes, now I'm thinking of certain Article 6 cases involving Italy, which has a not very swift...
No, this is rather different.
Judicial process. Yeah, no, it's a different point. They don't always come up, but nothing in our submission, nothing in the Article 8 cases we have seen would suggest, and nothing that Europe says would suggest that you do need to keep on looking at it, because frankly, no disrespect, I don't want to exaggerate, but yes, this is a recipe for grinding the recovery of possession to a halt.
As I understand it, the passage that has been referred to is reading into Section 85.2 a power to go back to the court. 85.2, which is quoted actually at page 1537 at the beginning of the report, seems to be directed to the first stage, that's the making of the order of possession. The court shall not make an order of possession unless it considers it reasonable to do so. I think that's what it is, and the way Lord Justice Chadwick is putting it is that it's always open to go back to the court to ask it to reconsider it. That's already made the order.
852 is at paragraph 7.
Yes.
I'm sorry?
852 is at paragraph 7.
Yeah, thank you.
Is it?
Yes, the court can always be invited, but the point is...
At any time before the execution of the order, the court may stay or suspend the execution of the order or postpone the date of possession.
That's Section 84 in the note, I think.
Oh, yes.
That's Section 85.2
Yes.
of the 1985 Act. And of course, the problem with St. Bryce is that it was a secure tenancy, there was a suspended possession order, there was the power to go back to court. We've just been through all of this in Austin. To try and get the possession order changed in some way. Your point is, forget a statutory power to do that. What if you've got a possession order and there is no equivalent of Section 85.2, but you want then to get a warrant to execute your possession order? Does there have to be a proportionality assessment all over again? Given that there was one when the possession order was made. That's your point. You're saying you don't see anything in Strasbourg that says that there should be.
Yeah. I'm saying certainly if there's any substantial delay, you would be able to go back on the approach being taken. What we're saying is that the Strasbourg case law doesn't go that far, that you are entitled to execute the consequences of a proper order. That's one that's under Article 8.2. Sorry, yes, proportionate under Article 8.2, within a reasonable time. And what we're saying is that eviction within 1 year without a further proportionality hearing, which is precisely what has been ordered, the first hearing, is sufficiently proximate not to require a further independent proportionality hearing. Read the legislation that way, then of course we really defeat incompatibility. Actually, it's an end to incompatibility, isn't it? If you read the legislation that way. If you're tended to read legislation so that it's compatible, I'll be using that in a different way. Can I move on to forum, Lord? Deal with it fairly briefly. We take it up at 187 of our case. Lord, the reason I go to it, although my learned friend Mr. Stirrett did deal with it, he dealt with Cochrane, but he read only a certain part of it. The passages on which we rely are set out in our paragraph 190, the second and third reasons. He read the first reason. We didn't think that actually bit. In the light of that's okay. And the light of K, because although I appreciate this is coming up in your Lordship's November delights in this area, and it came up in Mullen, the argument is being raised again that Wandsworth and Winder was limited to the defence of private rights. That was a line of decisions the Court of Appeal took after Wandsworth and Winder. They cut it back in a sense. My learned friend actually set this out in his I think his ground as well in his printed case. Some detail. There was a cutback of Winder to cases where you were defending a private right. In cases in the Court of Appeal, Avon and Buscott, we'll set these out. In K, that was the basis on which Lambeth, I, relied to argue. It was an argument we ran rather tamely, and I agree, it did not occupy the court for long. Lord Scott answered it in a very forthright intervention, and I decided to move on. Lived to see my children grow. It was, if it was unlawful, it was unlawful, and you don't give effect to it. A view I wholly agree with, and there we had it. In our view, that ended, because there were no private rights in K, that ended that, it was an essential part of the ratio that you could raise Wandsworth and Winder where you weren't defending a private right. I understand, as I say, that has been raised again in the Court of Appeal. I think the Court of Appeal judgments deal with it. It's all for them. They say they're back. Very briefly, it's not an argument I support. Manchester's support for it in the Court of Appeal should be ignored. It was a bit aberrative, and we don't seek to go behind that. And that's why we didn't rely on the first argument in Winder. And a friend took the attention, using the printed case that we made. The second reason is the comparison between Part 5 and 7 of the Housing Act 1996. We would say the comparison is even stronger if you set Part 6 in. Can I make this point very briefly? I don't think we'll need to actually go to anything we can if we have to. Part 3, the introductory tenancy regime. Sorry, Part 5, I've done it again. Parts 5, Part 6 and Part 7 of the Housing Act 1996, as enacted, all contain provisions for internal reviews. In fairly similar terms, and regulations were made in fairly similar terms governing them all. Part 7, which is homelessness, was the only one to be given a right of appeal on a point of law to the county court. And it was explicitly withheld. It could not be read otherwise than being withheld from parts 5 and 6. And that is what the second reason is saying. On the construction of the statute, it's quite clearly envisaged that there would be no appeal on a point of law, and yet that is precisely the same jurisdiction or same legal approach that would be applied on a Wandsworth and Winder defence.
But Part 7 has a different statutory origin from the other parts, doesn't it?
No, but it had no review in the earlier provisions.
Right.
The appeal on a point of law was introduced by Part 7.
Right.
So was the review, the statutory review.
Right. Thank you.
The purpose in Part 7 was all of which was canvassed in our league, was to get the backlog out of the administrative court of the Crown Office, what it was then called. But it was explicitly given that jurisdiction by, my Lord will remember that, by Part 7. So it didn't follow from the earlier legislation at all. Third reason is procedural, and we now get to the point which is really it's central, but it's quite simple. The county court has no power to quash. That's section 38, County Court Act 1984, still in force. It has no quashing power. There's no power to make prerogative orders. Sorry. Therefore, and subject to an argument we raise, as a sort of fallback argument, advocating a change, if I'm wrong, about form, we ignore that argument for the moment, but if we ignore it for the moment, subject to an argument like that which hadn't been raised at any time before, the county court, if it found an illegality in the review procedure, would then dismiss the claims of possession and the tenant would become secure. That might follow from a relatively minor failing at the review stage. And that, it was said, could not be Parliament's intention. And that reasoning, at least as law is cited, understood now, applies like for like now. On the other hand, if the court adjourned for judicial review proceedings to be taken, as Cochrane understood it, and I don't know if Mr. Travell says wrongly, so I have to come to that. We say rightly, Cochrane understood you could quash the review, so notice initiating proceedings would have been done in time. You would then go back, the authority could then go back, redo the quashed review, either drop the proceedings, of course, if it found in favour of the tenant, or resume the proceedings. Now that reasoning led Wade and Forsyth to refer, and we quote it at 189, as an express exclusion of the Wandsworth and Winder procedure. That reasoning, in our respectful submission, A, was explicitly adopted when the introductory tenancy scheme was adapted for demoted tenancies. Cochrane had been decided by then. And B, it continues to apply. Julie, where is Cochrane? I think I've covered it. Right, I have covered it. And we've set out all the cases on which we rely for this scheme, parliamentary scheme approach. It is important to bear in mind the consequences and how it would work. In our respectful submission, it remains the case. Parliament cannot have intended that if we make any slip between initiating the procedure in the course of the review and the proceedings, the tenant should become secure again. And Lord, I think Mr. Drabble accepted and hasn't challenged the Court of Appeal's view that the time requirements for conducting the review were directory, not mandatory, and in effect that has to happen. Otherwise, you'd axiomatically get a clash. For example, if the person said, I can't get legal representation here today for this reason or that, or I'm ill, and you didn't adjourn. So we respectfully accept that, and we think that hasn't been challenged. It is absolutely wrong in our submission to suggest that because the review procedure may have been mishandled procedurally, that there is any basis for going back and quashing the initiating notice that was otherwise lawful at the time. Mr. Luber suggested this in response to the tolerated trespassers point put by my Lord Newberger, which I don't think was his best answer for the reason I given before, and it's a bad answer anyway. Can't go back and start quashing things that were perfectly valid at the time for reasons of administrative convenience or tidiness. That is not to say, and we have not said, that judicial review, none of this goes to what the grounds are, Lord, of course. This is purely a procedural discussion. The judicial review could not lead to a quashing of the initiating notice. There could be a void notice. A notice might have been procured by corruption. Say, please evict my next door neighbour who I do not like. It could have been vitiated for other reasons of bad faith, but merely getting the facts wrong is not enough in itself. All that a notice seeking possession or notice of possession proceeding is saying is, we, for these reasons, having gone as far enough into it as we are obliged to do so, have an honest belief that we have grounds to seek possession. That is all it says, and we've set out a case, Dudley and Bailey, and we think that this also comes out ultimately with a little more difficulty than we think it merited in a number of Court of Appeal cases recently. I don't want to take up time going to it because it seems to us self-evident that while a notice to quit could be vitiated, is not vitiated simply because, notice of proceedings, simply because it's got the facts wrong about the arrears and so on, as long as it was a good faith belief. Otherwise, every time a local authority went to the county court alleging 5 grounds of nuisance, but one was wrong, was held not to have happened, the proceedings themselves would be vitiated. That clearly cannot be right. Sadly, there is no one-size-fits-all answer. Of course, something I'm saying about everything here. The effect of a failure of a relevant, this is at 204, failure to take a relevant matter into account depends on whether the authority needed to investigate that matter for serving notice, whether a reasonable authority could have proceeded with the notice at the time. It is even possible that an authority might proceed with a notice even though at the last minute someone says, well, my son couldn't have done that, he was in Brighton or in prison at the time. The sort of fact which could be gone into on judicial review. But if we couldn't investigate that and we had to serve within the statutory framework within a couple of days, we might well say, well, look, we're going to serve it because our present belief is, but we will look into it then and we'll withdraw it. We've always accepted it's a continuing process. That came up in this court below, and we accepted it there. I'm not sure if that is time, because I was going to move.
Yes, so the, what happens if the procedures haven't been followed under 143F, 143D, is simply that the court declines to make the order, and then if 6 months elapses, the secure tenancy will revive. Is that right?
No, because we've still got the order pending.
I see, so...
Still got the order pending.
I see, so...
Perhaps I can come back to it. I confess I don't keep details clearly in my head. But there will come a time when we do.
Yes,
do lose for reasons of time, but I don't think it's 6 months.
Very well.